Oh, good. Thank you, Mr. Chris.
Okay, hearing will come to order. Roll call, please.
Chairman, Mr. Coppola.
Here.
Vice Chairman, Mr. Brosens.
Here.
Supervisor, Mr. Love.
Here.
Township Manager, Zoning Officer, Mr. Behrens.
Here.
Solicitor, Mr. Smith.
Here.
Township Planner, Mr. Grossman.
The reason for the hearing is to consider for adoption ordinance number 04-13 entitled An Ordinance of the Township of Robinson, Washington County, Pennsylvania, amending the official zoning map of Robinson Township. In summary, the ordinance purpose is to amend the official zoning map of Robinson Township in accordance with the comprehensive rezoning detailed in the proposed amendment to the zoning ordinance of Robinson Township, titled An Ordinance of Robinson Township, Washington County, amending Chapter 27 of the Township Code by amending the zoning ordinance. At this time, if anybody would like to make a public comment during the hearing, and they have the court reporters swear everybody in that would like to make a comment.
If you were already sworn, you have to be sworn back in. If you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Thank you.
Mr. Chairman, as an initial matter, we're going to incorporate by reference all the exhibits that were introduced in the first hearing and all the testimony that was introduced in the first hearing to be part of the transcript for the second hearing. So if you feel you need to repeat yourself, by all means, but everything you said in the first hearing will be part of this transcript, and all the exhibits that were introduced by the public and by the township will be incorporated into this record. Mr. Behrens has very similar exhibits, so instead of going back through 1 through 16, that's where we are. So, Mr. Chairman, would you like to have your planning director speak to these issues?
I believe you probably addressed most of them with the township, with the township ordinance.
Yeah.
So I'll just open it up to
the public.
the public comments, and this is for the zoning map. Are there any public comments? Mr. Young.
Thank you. John Gallagher, 10 years old, Brady, on behalf of Range Resources. And my first question is, what is the planning rationale behind the creation of the oil and gas overlay district?
Well, that's the next hearing. We had 3 hearings, we had to do them separately, so that's going to be the next hearing.
I thought there were 3 hearings.
We are on the second hearing.
When I tried to ask a question on the map last time, you told me to hold off until this hearing.
Well, so the next order here is the oil and gas overlay district. If you want to ask a question on the map,
My question is the same. What is the planning rationale behind the creation of the overlay district? Because there does not appear to be any rational basis for the creation of the
as
district.
far as the location of the district,
Yeah, I mean, it split zones, properties right in half. It's created, it's located in at least 4 or 5 zoning districts. So what is the planning rationale behind the creation of the district?
the planning rationale is to cover the entire township. And we started with the areas that are already drilled in the industrial zone. So that was fairly easy because the entire industrial area can be in the overlay district map. The other area we went to is in the northern portion of the township. I believe Chevron currently has that under lease. That was another area that was easy to do because that entire area is already has drilling activity on it. Then we went to the areas that were proposed to be drilled. We had one proposal for the frame site, proposal for Mr. Kendall's property. We added those into the overlay district. We have the Duran area that was indicated a couple of years ago that would be another drilling site. And then we have the area off of 980, which is owned, I believe, by Imperial Land. There's a drilling site located on that parcel, so we included that parcel. Now we do recognize that there are 2 other pads on the area between Quicksilver Road and 980 that are also located on the Imperial Land property. We didn't include those in because and I'm going to state that for the record that we recognize that those will be legally non-conforming uses. And we do anticipate that those are going to have further wells drilled on them. Because of the turnpike route, we weren't sure about the route. We didn't want to put a overlay district there We're not knowing exactly where it might affect the turnpike, but we do understand that those are going to be drilled further in those two districts.
Then I can ask Mr. Grossman, what the planning rationale is behind the creation of the district?
I was not as intimately involved in the creation of the district. In fact, there was another company actually did the map work. My understanding of it is to meet the municipality planning code goal of giving reasonable access to minerals in the municipality.
Yeah, well, I mean, why would you split zone properties? And is it not true that in planning, you zone an entire property? That's just property.
No,
Entire lot.
quite frequently, depending on the size of the property, quite frequently there are many good reasons to split zone property.
Well, it's kind of what are the reasons here? Because they look fairly arbitrary to me.
Could you explain an overlay district and how it works and what we can do with an overlay district?
Sure. The overlay district concept is most traditionally used for other things such as floodplain, and that's usually a good example where you actually have something that's defined by hydrology. But floodplain frequently splits the property. If you have a 50-acre farm, maybe only 10 acres of that farm is in floodplain. That's one of the purposes for overlay districts.
This isn't a floodplain issue. This is an oil gas overlay.
No, but I'm answering Mr. Capola's question to explain what an overlay district is. An overlay district gives the township the flexibility to create standards for something that transcends many different zoning districts. So it's not a use-based district solely. It's based upon giving reasonable access to minerals. So you may debate the size of the overlay, but I think the overlay concept is to create some flexibility.
Well, the zoning ordinance permitted oil and gas development in all zoning districts, so limiting it to less than 10% of the zoning district doesn't seem very flexible to me.
It permitted it as a conditional use, and that's where we ran into a problem. And I think most of the discussion with Mr. Smith centered on the legality of including it everywhere. And that's where we ran into a zoning issue with compatible use. I'm going to let Mr. Smith discuss that issue that we had with where to put the overlay.
And oftentimes, when the township wants to restrict, let's say, drilling or industrial activity in a residential area, like Cecil's more easy to look at here, we have maybe 80% residential. If you said no drilling in residential areas, you'd say no drilling in 80% of the town. So what the overlay does is come in over top of that district and say there are patches of residential that would be compatible with that, but we can't have it both ways. We can't restrict it residentially and then allow it everywhere. So what the township looked at in this instance was making sure that no matter where the zones were, that all parts of the township could be reached horizontally in terms of the different pad areas, that if the company wanted to drill out the township, either from Robinson Township or from, we can't control neighboring townships, but what we looked at was from Robinson Township, and they could reach everywhere, every particular parcel, assuming that they have the drilling rights in those particular areas. So that was sort of the concept. We're all waiting for, of course, the Supreme Court to rule on Act 13 as to what the court will do as to where you're allowed to drill, where you're not allowed to drill. The Commonwealth Court did agree with Robinson's position about compatibility. And so there was a question of, as of right now, could we allow drilling in a residential neighborhood? And because we can't really restrict, we don't want to restrict universally by district. Some of you may have residential district with 200 acres of farm, and that wouldn't be fair to us to say no drilling in that particular district. The overlay took a look at some of those and came over top and said portions of those areas wouldn't be available for drilling. Tied into that was having this go to the zoning hearing board as a special exception, because the board recognized that a driller may come in and say, I can't, I've looked at every possible solution, I cannot drill Mr. Campbell's property, I can't reach it from anywhere I want to be. So, like any other hardship candidate, an industry could come in before the zoning hearing board, either by special exception for a specific site, or by variance saying, I meet this hardship and I want to be able to drill in that location. In both scenarios, the zoning hearing board would have the ability to make that call. Now, I wasn't involved with the actual map and didn't do the calculations, but And I don't know, Sean, if range has a position about how far. I know typically companies can go up to 2 miles from a drill site, so, and I know that keeps getting further.
I mean, there's no rational basis for the creation of this district.
Well, do you know how far range can go horizontally?
I don't know how, anyway, I don't even know if they could put pads in these districts.
Well, assuming that they could, do you know how far they've drilled horizontally?
I can't speak to that.
Mr. Cannon, do you know? Oh.
They, the map that we did.
But, that's irrelevant. These are from, most of these you said are from existing well pads, so you're essentially precluding the development of new.
No, just the whole area. If there's a well pad in that area, there's nothing
But,
precluding.
here, Mr. Bishop, there's no rational basis for cutting this property in half or this property in half. When you look at this is why the whole district at one time was RA, because the township is pretty wide open. They're large lots, and they're all suitable for oil and gas development. What makes this area and this area different than any of this right here? And the answer is absolutely nothing. That's why I'm asking for the planning rationale behind the creation of this overlay.
Could you explain the legality to everybody here of allowing an industrial use everywhere?
Well, that's what zoning, obviously, put oil and gas aside for a moment, because I understand the hot button issue with that. But there's a reason that I can't open up a Walmart next to your home, because zoning doesn't allow that. But I can't come in and say I'm going to put a steel mill next to your industrial or your residential areas, because zoning doesn't allow non-compatible uses to be together. So the township doesn't just plan for oil and gas. The township plans for your property values to stay up in terms of your homes, the future development. I know people talk about PRDs to make sure that if you're going to build those, that industrial uses won't come in every specific area and take away that potential right. So the board, in recognizing the value to all of its gas owners and mineral owners, making sure that they can extract the gas, look from a feasibility standpoint from some existing proposed range sites. I know Rice has some leases up there, and I believe Rice talked to the township about the ordinance and had some concerns, and I don't know if they were on board with the ordinance or not, I don't know. But we looked at from a feasibility, could you drop a well and reach different parts of the township from various locations? So as to why, Sean, one might be 2 miles apart, that goes to the horizontal bore. How far can you go before you need another path? I think that was the planning rationale.
Yeah, I don't think they'll pass muster, but, and then I have an additional question. So, where's this 7,500 foot buffer? And I didn't see this before, and it says revised on Saturday, November 16th. What is this buffer? Because it looks like it essentially zones out all oil and gas development.
No. That map we asked to be printed so that we could put it up on the wall. We've had these small ones for a long time. That map was just printed a couple of days ago to put up on the wall. What that is that's the areas that can be covered at 7,500 feet horizontally from all the overlay districts in the township. And you can see, and we were told 10,000 feet horizontal. We did that, when we did the overlay district, we figured 7,500 feet, so that there'd be no place that would be missed. That's what we covered from the overlay district in the township. It's complete coverage of the township. Assuming there's no drilling coming in from outside the township, that's just Robinson Township overlay district.
Thank you. Was there any, what was the comments from Washington County Planning Commission?
They basically, their commentary was more grammatical. They had some issues with phraseology, real simple items. They didn't really have any comments about the drilling side of this.
Okay, well, it looks like it is, there's some severe concerns I would have about whether or not this zoning overlay district is unduly exclusionary.
And that's the reason we set it up as a special exception.
There's no difference between a special exception and a conditional use. The law is identical.
Well,
One goes to the board of supervisors, one goes to the
And
zoning hearing.
what can the zoning hearing board do that the board of supervisors can't do? The zoning hearing board can grant a variance, and this has come up, for more areas where well pads can be put. If there's an issue that comes up where those sites can't be reached from that existing overlay district, the zoning hearing board is the only board that can grant grant a variance to put a cabin in a different location.
And the variance standard is exceptionally high and difficult, so you're saying it's okay, you can pretty much do anything you want, but you're gonna have to come in and prove a difficult standard that you'll never be able to reverse on appeal.
I don't think that's true at all. I think that we're acknowledging during this hearing that because of the different drillers that we have in the township, if we had one driller, that overlay district is sufficient to get everybody drilled. I don't believe well, we've got different drillers in the township, and I understand that there will be a time where somebody may have been leapfrogged and they have a different driller, and there's going to be a need for another pad to be put somewhere. And the zoning hearing board can do that. I'm stating it on the record for that. That's the intention of the way it was set up.
One of the other issues, Sean, that I know that industry brought to the board's attention was that they didn't like the going to the planning commission and then going to the board of supervisors, and they liked the concept of the zoning hearing board because you're right into the fray right out of the gate. So that was one of the other reasons. But I understand your concerns. I mean, they're not unusual concerns raised in a number of communities that use overlay districts for drilling. I know South Fayette does, I know Cecil does, I'm pretty sure Peters does. I haven't looked at all of them, but
I would ask that you at least table consideration of this so you can allow for industry to give their comments on where they can and can't operate.
yeah, I did get your letter this evening, and I got through as much as I could. So
Did you have in your letter the additional areas that you think you may need?
I only reviewed this in the past couple of days.
Or do you think within the next couple of days you could give us the additional areas that you may need?
We'd ask for at least a couple of weeks. Wow.
Any other public comments?
Yeah, John Campbell, 738 Campbell Road,
This is the zone. I know we got a little off track.
this is just the map, not the overlay. That's coming up next.
Yeah, just one comment to make a minute, and I want it on the record, that I understand that the zoning hearing board and the planning commission is controlled by the supervisor. The input that they give is overridden by the supervisor.
Absolutely not. The zoning hearing board, Mr. Gross is on the zoning hearing board.
I know.
They are independent boards.
I hear what you're saying.
That's
But
absolutely
the word that's
not
out in the world, in Robinson Township, it's controlled by the supervisor.
Absolutely not.
That's
They
It's overridden by the supervisor.
absolutely.
well, Mr. Campbell is correct. By law, they're appointed by the supervisors to serve various terms. And the new supervisors will probably have the opportunity to appoint people as well. Planning Commission is a recommending body, and
I would like to go for the record that I would not want my property changed to interchange business because I'm at an interchange that has limited access. So even if I wanted to put a business there, no one could get to my property.
and those are similar comments from your first hearing, right?
Was that what you were referring to before?
Yeah. You can't get off that interchange. You can't get off of it.
Any other public comments on the zoning map?
And we'll get back into the overlay map in
We're gonna
a
do that.
minute.
So this is about, we're talking about the overlay, correct?
No, this is just the map itself, and then the overlay will be the next hearing.
Okay.
So I know they're all together to some extent.
While we're still on the zoning and the zoning map, gentlemen, sit next to you. Mr. Watson, you had objected to the designation of the district. As far as what you can do in the district, nothing really changed, it's still residential. But you were objecting just to the way it was designated?
That's my primary objective, yes. But I'm also a leaseholder, and in reading the present zoning laws, it said that oil and gas permits could be applied for in all districts of Robinson Township except the floodplain at the very southern tip. In reading the new zoning laws, it was only under agricultural and industrial.
Well,
Where permits could be applied.
It's the overlay district. It's several districts, it's just an overlay.
So what you're telling me then is that even though I'm in this special conservation district.
Well, there's a big overlay district up in the northern portion of the township. It's probably pretty close to you.
The green at the top, is that what you're referring to?
No, it would be the next one over. Mr. Gallagher's talking about. There's a large overlay up there. But that was your objection on the designation.
I despise the word spot,
Yeah.
and I'd like that changed.
We talked to the planner about that, so we're going to look into that.
And I never did get an answer how we could be classified as an environmental hazard.
I think, again, the planner said that his choice of words, be they poor or not, as he indicated, he looks at environmental hazards differently as you do in terms of they're not toxic, they're slopes, they're severe drop-offs, things like that. But the board, I think, agrees with you with the language, and that's something they're going to look at.
Lady in the back.
I'm Alice Palmagini, I live at 131.
Wait.
Alice, what was your last name?
Palmagini,
Can you come up a little bit further? I cannot hear you.
I live on Emma Lane, Alter.
I can't hear you.
Still?
Yep.
I wanted to make a comment as to the overlay area, the northern area of the township. As far as I can tell from where I live, that is an area already occupied by Chevron. So if I had a lease with Range, I'm not sure how Range could actually drill a hole there and access our property horizontally. That's already an area that Chevron occupies.
And I think that's the reason we need some input from the drillers as to where they're drilling, maybe in the adjacent township, where they intend to drill in the northern portion of the township. Because right now, we just don't know where they would want that pad at. But as Mr. Smith and I were explaining before, that's one of the reasons that it's at the zoning hearing board as a special exception, because if that came to fruition where they couldn't access your property, the zoning hearing board could grant them a variance to put another pad in another location.
Mr. Chairman.
Sean Kramer, 232 Robinson Church Road. I also would like to note that my property under this new plan would be changed. I would like it to be considered that it's stable residential, because under industrial or interchange business development, you cannot see my property from the turnpike. So if I wanted to start a deer processing plant or some adult entertainment facility, that would not be profitable for me. Please take that under advisement.
Whose property is between yours and the turnpike?
Synergy.
There's another small piece that's south of yours that juts out towards the turnpike.
South.
Who's
South.
Homes?
And Borovich. There are several families who have signed gas leases that you put into that district right there, into that business district. And there is no way to get, unless you jumped off the turnpike, you cannot drive off of it.
For the gas unit? For gas unit? For business. Oh, just the access.
For business.
Well, we're gonna probably, okay, we're gonna probably go to the next year. Is there anything else from the board of supervisors? Now, if not, is there a motion to close the hearing?
I'll serve it.
Is there a second? Second. Mr. Rosens?
Yes.
Mr. Law?
Yes.
My vote is yes, motion carries, hearing is closed.
Jim, you're good to keep going?
Hearing will come to order, roll call please.
Chairman, Mr. Paula.
Here.
Vice Chairman, Mr. Broseph.
Here.
Supervisor, Mr. Love.
Here.
Township Manager, Zoning Officer, Mr. Behrens.
Here.
Solicitor, Mr. Smith.
Here.
Township Planner, Mr. Grossman.
Purpose of the hearing is to consider for adoption ordinance number 05-13, entitled an ordinance of the Township of Robinson, Washington County, Pennsylvania, creating the official oil and gas development and operations overlay district. Purpose of the ordinance is to create an oil and gas development and operations overlay district in the township that identifies areas in which oil and gas development and operation will be permitted as a use by special exception. This time I have the court reporter swear in anybody that would like to give testimony or raise your hand, please.
Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Exhibit centered in the room.
With the, consistent with the last two hearings, we will incorporate the first two hearings into the third. So all the exhibits that have been introduced will be found in the third hearing as well. And all the testimony that all of you have previously introduced will also be part of the third hearing as well. Now, again, that doesn't negate your ability to provide additional testimony, but everything you've said this evening is part of each hearing. Okay?
Are there any comments from the board? If not, we're going to go right to public comments and try to be brief, please.
Sean Gallagher, on behalf of Range Resources again. At the outset of the hearing, I submitted a pretty detailed letter with the comments that went over all the provisions in the oil and gas development standards in the zoning ordinance. And in short, there are a lot of constitutional issues with the provisions as drafted, as well as provisions which are contrary to state law and unprecedented. And I would ask that no vote be taken and consideration be given to our comments. But with that said, I will address a few. I have a question. My first one is with respect to the definition of residual waste, which is essentially a verbatim restatement of the Solid Waste Management Act's definition of residual waste, with the one addition of adding drilling to the definition. And my question is why?
Mr. Smith is going to have to answer that.
Sean, what page of your letter are you referring to?
Page 5, definition section. The first bullet point is the zoning amendments definition of residual
Okay, I see.
waste.
I think
that is the solid waste management.
Yeah, I don't know, when I looked at your comments briefly this evening, I don't know that I disagree with that, obviously, that definition. I don't have that act in front of me. I know it's very similar, so it may be verbatim. So I know the township wanted to make sure that they could define as many definitions as they could, because you know from past hearings there's been issues as to, I know you take issue with the word site plan as well, as to what those things mean. And I think to be consistent with state law, that was why they drafted in a residual waste section. But I told the board after I got this, that some of your comments deserve going over. I just haven't had a chance since I just got them this evening.
Yeah, the residual waste is a defined, it's a defined term in the Solid Waste Management Act, and you use that definition. You can't change in the zoning ordinance what residual waste is under state law.
Well, I understand. I don't think they're changing. They're trying to be consistent with state law.
It's inconsistent with state law is our comment. So we would be removing drilling from that definition?
Drilling?
Yes.
Yeah, you know what, Sean? I have to look in connection with where drilling is, take a look and see if that's possible.
Fair enough. I can go through every single one of these, but that's why I asked that you table this to consider the comments.
Mr. Gallagher, I can assure you that we are going to look at your entire.
Yeah, had I had it before the meeting, I'd have looked at it all.
So you will have an opportunity in the future to address every one of those.
Okay, I just have a couple more comments. And one, you have that after an application is submitted, that an applicant can not present any testimony or evidence at a hearing unless it was submitted with the application. And that runs afoul of procedural due process. What's the point of making a special exception then? Because that's an evidentiary hearing.
Well,
You're supposed to support evidence and present testimony different than your application, actually in addition to. So to prevent somebody from entering evidence at a hearing is a direct violation of constitutional protections. And my question is, If you're gonna have such a requirement, why not make zone or oil and gas development use permitted by right?
I assume that the board in doing that doesn't mean that they're going to negate your ability to introduce evidence at a hearing.
That's what it says.
What they want to negate is the ability to change the application. So when an industry comes in, which we've had in the past, says that we want this approved and here's our application and scheduled for a hearing, and when the time they get to the hearing, it's something different. And Mr. Kapoor, I think that was the basis for that language. Now, I'm looking at your letter, I'm not looking at the actual ordinance, Sean, so I will go back and look to make sure, because you're right, you have the ability to introduce evidence to support your application. That's not what that means. But if it's drafted poorly, we'll go back and take a look at
That's
it.
drafted poorly. Then the other thing, one of the other things is that you're supposed, the zoning ordinance requires sound mitigation measures and sound barriers be constructed around the entire well site. And it seems, well, there's a lot of issues with it. Well, I mean, how can you require that, one, if use complies with the zoning ordinance's noise provisions?
Well, in order to allow it everywhere that we did, because if you look at the ordinance, it says in the industrial district that requirement can be waived. But in order to allow those activities in the residential areas, we had to build in some sort of a protection to enable that to be done, but yet not be compatible with the uses in that district.
Well, doesn't decibel limitations in zoning ordinance accomplish those purposes?
I don't think that, I've never seen a heavy industrial use that could meet the decibel requirements in the residential area.
Well, it's not at one. I mean, the characterization of a heavy industrial use is, I mean, that's your characterization, but I mean, when you look at some of these properties, they're wide open, Mr. Sokola. So if you can put in an oil and gas well here and there's decibel requirements on this property line or this property line, there's no need for sound barriers.
Well, if that's the case, you can ask the zoning hearing board to waive that requirement, if that's the case.
But there shouldn't be a requirement if you meet the zoning ordinance. I mean, you get into disparate treatment of different uses.
I don't think it's disparate treatment. I think it's a recognition that any other industrial use would not be allowed in that
That's
area.
exactly right. See,
That's the favoritism, because we recognize that you need to drill in certain areas, but we're not looking to punish you. I think you're just looking to make sure that if you can meet that, I think you can ask for the waiver, and if you can't, then the sound walls would be there for mitigation purposes.
There are also, aside from the noise, the dB issue, I mean, there are issues with putting sound mitigation measures around an entire well site because it makes it impossible to operate. There are safety issues.
Well, I know in Cecil, I think you put them around the entire well site.
What did you do here in Robinson? We required those on the range pads here. They did it.
Well, the ones I represent are still in court right now.
Yeah.
The ones that they actually
The
drill.
ones that we approved, 3 sites we approved that sign area, those no issues with that.
I can't speak to those.
Those barriers run on all 4 sides. Right.
Yeah.
Yeah.
Were they on 3 sides, Brian?
One of them had 2. One of them, I believe, didn't have any sound barriers. The other one had 3.
Because of the location.
Yeah, but I've never seen one fully enclosed with sound barriers.
And it's required during construction, so you make the construction almost impossible.
Sound barriers are required during construction?
It says during construction.
Okay. Is there anything else?
Yes, sir.
Yeah, I think I have a problem with the procedure. I don't have a surface permit, but even if I did, if I wanted to put a pad on my property, by going directly to the zoning hearing board, that's a one-throw crapshoot. If I'm turned down, I don't even have an appeal.
No, you do.
But if you go through the planning commission, I at least want my neighbors to have the opportunity to come in and say what their concerns are. And I want to go before the board of supervisors for another opportunity for input of my neighbors, public input. And then if there's a problem, I can appeal to the zoning hearing board.
No.
You by going, well, if.
Let me tell you the process.
RPC.
So I respect your ability and desire to make sure your neighbors have an opportunity to be heard. I think that's great. The zoning hearing board could have multiple hearings if you so please. I mean, I doubt that you would want that, or the operator, but they can have more than one hearing. The planning commission is a recommending body, so they just recommend to the board, and there is that particular hearing, but they can't make a decision. Then the board of supervisors make that call. If the board of supervisors is for or against it, however the vote may go, but either party can appeal to the Court of Common Pleas. Same with the special exception. So if you're denied at that level at the zoning hearing board, you can take it to court. So there's always an avenue for appeal. And there's an avenue for a hearing. What it does is that, again, it takes it to the zoning hearing board where you may have an operator. I can think of some instances where we have people come in and ask for a special exception and a variance, recognizing the board may not find that it suits a special exception for whatever reason, but as the fallback, there's a variance opportunity as well.
Look, I still want my elected officials to make the decision, not an appointed.
Well, no, and that's a fair assessment, and it goes both ways. Some municipalities, I can think of a handful, rather have the zoning hearing board where you can put maybe more expertise, engineers or what have you on the board. Some want the elected officials to do it. So I get your argument either way.